the sessions do kind of follow on one from another. And then just to let you all know as well, we are recording this session, so we'll send that out after the event, and we'll also upload the video to our website and media channels. You will all be kept muted during the presentation, and there'll be no cameras either, but you can use the chat facility should you wish to, if you have any questions at all. And then what we'll do is there'll be time at the end for us to address those questions. And just before Maria gets started, I want to give you a brief introduction to the services that CFAB can offer. So CFAB's the UK branch of International Social Service. We've got access to partners in over 130 countries around the world. We're experts in social work in an international context, cross-border child protection cases, care proceedings that require cross-border cooperation, and overseas placements. We offer guidance and practical support on cross-border children and family cases. You can call our free advice line, which is available 5 days a week if you require assistance, and the number's there on the screen for you. We also provide casework services, including child protection alerts, completing record checks, welfare visits, and full assessments. We can provide pre and post-placement support services, family reunification support, and we also have a dedicated legal advice service. Our training programme can provide you or your organisation with in-depth content relating to international child protection, international kinship care, best interest assessments for unaccompanied children, and we have also developed an international social work certificate, which you can complete in your own time should you wish to. It counts towards your CPD, and it covers topics such as forced marriages and harmful practices, parental child abduction, and international child adoption, amongst others. I would urge you all to visit our website once the session's finished and just find a little bit out more how CFAB can support you with your cross-border cases. Our website is full of resources. There's free fact sheets available for you to download, and you can also view our International Kinship Care Guide, which is our good practice guide for professionals placing children from local authority care with family abroad. So just thank you all very much for your time this afternoon, and hopefully Maria's ready, and I'll pass you over to our senior legal advisor for this lunch and learn session, placing children with families overseas. Thank you, Maria.
Thank you so much, Angela, and welcome everybody. I'm so happy to see the numbers of people attending here. It's really amazing, and I think it just shows how often we are encountering international issues in our practice, that there are so many of you here present, so thank you so much. My name's Maria Wright. I'm the Senior Legal Advisor at Children and Families Across Borders, and today I'll be talking about placing children with family members overseas. This session follows on from the first Lunch and Learn session delivered earlier this year, which focused on the assessment process. And so, as Angela mentioned, if you haven't seen that session, you might like to have a look at it, because that goes into a bit more depth about some of the complexities associated with assessing family members overseas. And there is a link to that in the slides, which you will receive after today's session. So firstly, I wanted to just provide a really brief recap on some of the matters I spoke about last time in relation to assessing family members overseas, as it provides some context for today's discussion. So it's well established that the UK is an increasingly diverse population, and with globalisation we encounter children who have multiple international connections, family connections. And for children who can't safely remain with their parents, it might be necessary to explore whether their best interests are met by a placement with a family member outside of the UK. But assessing whether that would be in the child's best interest can be a complex process. In particular, the legal and practice frameworks for assessing kinship carers, which we use in the UK, are not designed with cross-border relationships in mind. And a cross-border kinship assessment requires some quite specific considerations. So there's a need to address the nature and the extent of the child's relationship with their family, member overseas and what this might have looked like in the past, and how, you know, the strength of that connection and how it might continue going forward, what life might be like for the child living in the other country, and the impact on the child of leaving the UK to go and live with a family member overseas. And in this context, I spoke about the importance of local assessments, which might form part of the overall assessment picture and assist with obtaining an assessment which is both legally compliant and culturally relevant. And those are the two core requirements which are referred to in the best practice guidance on special guardianship in its section about overseas placements. I also spoke about the 1996 Hague Child Protection Convention and how this instrument might be used to support and facilitate the assessment and placement of a child in another contracting state to the convention, including the role of central authorities to support this process. And in connection with this, there is a regulatory requirement which comes from Article 33 of the 1996 Hague Convention, which is often necessary to consider when placing a child in another contracting state to the convention. And what that provision essentially requires is that the overseas authorities consent to the placement, having determined themselves that the placement is in the child's best interests. So you can see that there are some quite specific legal considerations that need to be borne in mind in the context of exploring an assessment and placement of a child in another contracting state to the 96 Hague Convention. I want to summarise the 96 Hague Convention for those who might be unfamiliar with this instrument, because it comes up a lot when we're talking about working in a cross-border context with children who have family connections overseas. So this is an international convention which applies between the UK and a number of contracting states globally. It governs cross-border aspects of children's proceedings. So it applies to both public and private law children's proceedings. It doesn't apply to adoption, it doesn't apply to surrogacy, but it does apply to most children's proceedings where some kind of decision is made about the child's care, welfare, and who will have parental responsibility for the child and care for the child going forward. The Convention serves 4 core functions in children's proceedings in the UK. So firstly, it contains rules about jurisdiction, which tell us which countries' courts have the power to make welfare decisions about a child. It contains rules and provisions for the recognition of court orders between contracting states concerning children, and I'll be coming back to that as it's obviously relevant to today's discussion. It contains cooperation provisions, which I spoke about in detail last time, but in summary, what they do is every contracting state to the 1996 Hague Convention has a centralised institution responsible for facilitating cross-border cooperation called the Central Authority. And through cooperation via the Central Authority, it's often possible to obtain relevant child protection information from other contracting states, and sometimes also to obtain an assessment of a potential kinship carer in another contracting state. So here we can see a mechanism for obtaining an assessment through the convention. And then finally, there is the requirement often contained within the cooperation provisions of the convention that overseas authorities be consulted prior to a child being placed in another contracting state. And CFAB have developed a specific fact sheet addressing this because it can be quite a complex process. And finally, the 96 Hague Convention contains rules about applicable law, which I won't be talking about today. So I will be speaking about the mutual recognition provisions of the 96 Hague Convention, because what these can do is they can be used to ensure that a court order made in the UK placing a child with a family member overseas is recognised in the country where the child will be living. So these are really important provisions. And they're difficult to think about in an abstract way. So I'm going to address what they do and how they work in practice with a case scenario. But first, here you can see a list of the contracting states to the 96 Hague Convention. So this is a list that is constantly changing as new countries join and it enters into force. But you can see here that all the EU member states and the UK are contracting states to the convention. There are also a number of really significant contracting states outside of the EU. So in particular, we often deal with cases involving Australia, Russia, Turkey. And so it's a good idea, if you can, to check whether the case you are dealing with involves a country which is also a contracting state to the convention. So having introduced the convention, I just want to outline a little scenario to show how the convention might be used in practice to facilitate the placement of a child overseas. So this is a fictional scenario involving a child called Stefan. So Stefan is 5 years old. He was born in Bulgaria and moved to England when he was 3 with his parents. He's a Bulgarian citizen and his grandmother lives in Bulgaria. Care proceedings are issued in relation to Stefan due to a risk of physical harm. And Stefan's grandmother wishes to care for Stefan permanently in Bulgaria and wishes to be assessed. And so here we're dealing with a child who has quite a strong connection to another contracting state, the 1996 Hague Convention, which is Bulgaria. So we can think about using the convention in this case to support cross-border cooperation. So in this case, the local authority do that. They make a request for an assessment of Stefan's grandmother via the central authority. So the request is made to the English Central Authority for the 1996 Hague Convention, which is ICACU, ICACU, and is then transmitted to the Bulgarian Central Authority. And the Bulgarian Central Authority confirmed that the competent authority, so the local authority equivalent in Bulgaria, can visit the grandmother and can do an assessment. As I mentioned on the last occasion, it might be a good idea also when you're dealing with a potential assessment of a family member overseas to use other methods for assessment as well. So in this case, Stefan's grandmother also travels to the UK to meet the social worker and to spend time with Stefan. And all the assessments are positive. So the local authority here are contemplating that Stefan will be placed in Bulgaria with his grandmother, or at least that is a serious option for Stefan at the end of proceedings. So given that this is being reasonably contemplated, they make a request under Article 33 of the 1996 Hague Convention that the Bulgarian authorities consent to this placement. And the Bulgarian authorities have already positively assessed Stefan's grandmother. And so they're able to say, yes, we consider this placement would be in Stefan's best interest as well, because the grandmother has been assessed and we've seen that this is a suitable placement. So having been through that assessment process, having gone through the kind of regulatory hurdles that or steps that need to be followed under the 1996 Hague Convention, the question then arises, how will the legal framework around this placement operate in practice? So what's being contemplated for Stefan is a special guardianship order. Will this order be recognised in Bulgaria? Will it have any status in Bulgaria? And how will this impact on Stefan? And how will it impact on his grandmother? So here we can return to the 1996 Hague Convention and the provisions it contains for the recognition of orders. So a fundamental principle within the 1996 Hague Convention is that a measure such as a court order taken by the authorities of one contracting state will be recognised by operation of law in another contracting state. So theoretically, what this means is that if you have a court order from the UK concerning a child's care, parental responsibility, contact or access arrangements with a parent, On the face of it, this should be recognised in all other contracting states to the Convention and vice versa. So orders made about children overseas in other contracting states should also be recognised in the UK without having to do anything. So the mere existence of that order, evidence of the order, should be enough for there to be some recognition. However, we know in practice that presenting a foreign court order about a child's care, which might be in another language, might use completely unfamiliar terminology, may not be on a practical level of great assistance to the child or their carer in accessing the services and support they need and ensuring that their rights are respected in the country where they're living. So if Stefan's grandmother produces an English special guardianship order before the Bulgarian authorities, it would not be surprising if that was met with confusion or a misunderstanding about what it meant, or a lack of clarity as to her parental responsibility, particularly given that special guardianship gives rise to such a distinct legal relationship between the special guardian and the child vis-à-vis their parents. So for this reason, the 1996 Hague Convention allows any interested person to apply for a declaration that an order made in another contracting state is recognised. So Stefan's grandmother, for example, could seek a declaration from the Bulgarian court or the relevant Bulgarian authorities that the English order is recognised under the 1996 Hague Convention. And it's actually even possible to seek this declaration prior to the child moving overseas. So you can have that certainty that the order will be recognised once the child moves overseas. This is known as the advance recognition procedure. I would caveat this by saying that I don't think the advance recognition procedure is very often used, although it's obviously it could be really helpful because it can provide a lot of certainty for the child and their carer as to the recognition of the order. But I don't think that it's actually used very often in practice. Nonetheless, it exists. The other thing to highlight is that every country has a different procedure for recognition under the 1996 Hague Convention. So in some countries, recognition can be facilitated via the central authority. So I've linked here to some information that's produced by the Australian government about the recognition procedure in Australia, which is really helpful and clear, and which confirms the route for recognition. So it can be facilitated through transmitting the relevant order via the central authority. So it's a very simple and rapid procedure, which is what is intended under the convention. But in some countries, it will be necessary for the carer to make an application to court for recognition. And I could tell you the procedure in England and Wales for recognition applications, but I couldn't tell you with certainty the procedure in other countries. So that really is information that needs to be provided by the relevant overseas authorities. It is possible for recognition to be refused under the convention, and the grounds for refusal are contained in Article 23. And I won't go through them now, but I flag them because there's always the possibility of recognition being challenged if one of these grounds are made out. So they should be considered if this route is being taken. It's also possible to enforce orders under the 96 Hague Convention once they've been registered. So if, for example, an order was made that Stefan's grandmother facilitate contact between Stefan and his mother once a month, and the grandmother doesn't comply with that order, the mother might apply for the enforcement of the order, the registration and enforcement of the UK order and the provisions for contact in Bulgaria under Article 26 of the Convention. So it can be a useful mechanism to ensure that access contact rights are capable of enforcement once the child moves overseas. So I'm going to move beyond the 1996 Hague Convention and talk about mirror orders. So the intention of a mirror order is that the overseas court makes an order which reflects the terms of a UK order. So if a child is moving to a country which is not a contracting state to the 1996 Hague Convention, it won't be possible to use the procedure I just described to formalise their placement. And also, in some cases, even if the child is moving to a 96 Hague Convention contracting state, in some cases, a mirror order might be a better and more practical option, particularly if the child needs quite extensive state-based support, which can only be accessed through the relevant family court system. Recognition may not necessarily achieve that for the child and their carer. So on the last occasion, I spoke about a case where a child was placed in Italy following a positive assessment of a child's grandmother. And in that case, the grandmother was supported to obtain an order from the relevant Italian family court, which required social services to visit the child and visit the carer and provide support services to the child, a bit like a supervision order that you might find in England and Wales. And in this case, it was better for the child to have this type of order rather than simply the recognition of the UK order, because it opened up and unlocked a host of support services for the child in their placement. So it can be an option that is also considered where a child is moving to a contracting state to the convention, but mostly we do see it in cases where a child is moving to a non-contracting state. And it will always be necessary for there to be advice and information about the procedure for applying for an order under the overseas family law system. And when this happens, you would hope that what the advice will cover is information about the procedure, the costs, the timescales for making any application, and how the court overseas will determine the application. So what factors they will take into consideration. Is it likely that they will make an order in identical terms to the UK order, or do different principles apply? And so what it's important to think about here is the fact that the overseas family law system will govern the making of the order. And so it can't necessarily be guaranteed that the overseas court will make an order which completely reflects the UK order, because they will be applying their own law and the principles underlying their own family law system. So I've given a case example here. So this is a reported case called Re J, which illustrates this point. And this was a case involving a child who was going to be placed in Bangladesh with an aunt. And the aunt had undergone an assessment which was very positive. And in fact, all the parties agreed that the child should be placed in Bangladesh with his aunt. And so there was an expert's report from a lawyer in Bangladesh as to the procedure for making a mirror order, which would reflect the terms of a special guardianship order, I think was being contemplated. And what the lawyer advised was that the parties needed to submit something called a compromise decree before the court in Bangladesh. And that was essentially a bit like a consent order, and that would grant the aunt's guardianship in relation to the child. And so unusually in this case, that procedure was followed before the child actually moved. And when the compromise decree was put before the judge in Bangladesh, it was approved, but the court of its own motion then made an order that the child have contact with his parents twice a week. And so that order ran contrary to what the UK court had intended, because it was intended that the child only have supervised contact with his parents due to the risks involved. And it was in the judgment, this is described as a step being taken by the court in Bangladesh, which was in accordance with cultural norms around children having an ongoing relationship with their parents. And I think, in fact, the court in Bangladesh had not had information about the background concerns in the proceedings as well. But what this illustrates is that there's always the potential for the overseas court to come to a different conclusion or make a slightly different order, it can't necessarily be assumed that the UK order will be completely mirrored in the other countries. So it's just something to bear in mind. And what happened in that case actually was the placement did proceed and the parties were able, in fact, to agree a variation to the order that related to contact. And also it's important to note in that case that the aunt was very trusted to make appropriate decisions for the child and safeguard his welfare. And that was a really important part of the court's reasoning in that case. So I'm just going to give another really brief fictional scenario to see how the procedure for a mirror order might work in practice. And this is a case involving a child called Esther, and this is a fictional case, but the information from about the mirror order procedure is drawn from CFAB has a legal partner in Nigeria who is able to advise on the law and procedure in Nigeria for making a mirror order. So it draws on some of that. So Esther is the subject of care proceedings. She's 3 years old and is a dual British and Nigerian citizen. Her grandparents live in Nigeria and wish to care for her permanently. CFAB's partner in Nigeria undertake an extensive assessment of her grandparents, which is positive. So the question then arises, how can any order placing Esther with her grandparents be recognised in Nigeria? And so CFAB's legal partner in Nigeria is able to provide an expert report which sets out a number of matters, the family law system in the relevant state in Nigeria, because there is a different code in the different states. So this was a state-specific piece of advice. The report set out broad information about the nature and extent of child protection services in the relevant states, because what we sometimes find is that there is an assumption that there will be an equivalent state-based child protection system in other countries which operates in the same way to the UK. And so our legal partner is able to provide a little bit of information about that. Then the legal framework, which is operable in that state. So the options for permanence under the relevant child rights law. And this was actually a piece of legislation which was very similar to the Children Act. The procedure for making an application, so what the grandparents would have to do, what application they would have to make, and our partner advised an application for legal guardianship and custody and was able to provide details about the costs of that application and the timescales, as well as any ways that the UK court might assist with this process. So providing a copy of the relevant judgments, the findings made by the court, in particular, any findings which record why the child cannot safely remain in the care of their parents, why the court has reached this decision, will be of assistance to the overseas court in making its order. The report also contains what I think was quite an important point, which was to say that customarily the maternal grandparents can care permanently for children regardless of a court order. So kinship care is an accepted informal practice. And it's important to bear in mind that kinship care will not always operate as a highly regulated, formalistic structure for the care of children in every country in the same way as it does in the UK. So I want to summarise some broad considerations when exploring a child's placement overseas. I think it's important to think in all cases about how kinship care is regulated or unregulated in the country where the child will be living. So sometimes we receive inquiries about mirroring or recognising a special guardianship order in a country where there is no operating family court system, or there is no legal framework for the care of children by guardians or kinship carers. And so in these situations, it's quite important to think about what the purpose of this legal framework is. What is it going to give the child, and what is it going to give the carer, bearing in mind that what is being contemplated here is a child growing up and spending their minority in another country. So given that the child will be embedded in life and a legal system outside of the UK, what is going to be the best option for them, and what is actually going to help the child, and what's going to help the carer. And this feeds into the idea of is it the case that the carer needs a certain kind of legal framework to unlock access to local services, or do they simply need the recognition of their legal status as a holder of parental responsibility and someone with whom the child will live? I think if we can think about the different ways that kinship care is regulated and unregulated in this country, this can provide a helpful comparison. So, for example, a kinship carer may apply for a special guardianship order and may become entitled to special guardianship support services. How does that then compare to a kinship carer who is simply having the recognition of their parental responsibility and care of the child? And what is the child and carer actually likely to need in this situation? If the child is going to be placed in a 1996 Hague Convention contracting state, this opens up the possibility of using the recognition procedure that I described. The central authorities are a good resource for providing information about this procedure. In an ideal world, an overseas lawyer can provide advice on the precise procedure. And this will always be necessary if a mirror order is being contemplated as well. What we have here are some links to some relevant organisations to find out more about exploring options for legal permanence for children to live overseas. And the central authority, as I said, is going to be a really helpful resource when exploring recognition under the 1996 Hague Convention. CFAB also have a legal advice service, as I mentioned, where we have links to lawyers in other jurisdictions who can provide expert reports on the procedure, both in 1996 Hague Convention contracting states and in non-contracting states. Embassies are also a really helpful source of general information. In particular, I would highlight the Polish Embassy's Care Proceedings Unit, which is really helpful in providing information about how orders made in the UK placing a child in Poland might be recognised. And again, this is a procedure which can be supported and facilitated through the central authority. And CFAB have also produced some fact sheets which have a bit more detail on the process. So I want to just provide an overview, because I've spoken today about issues around the legal framework for placing a child with a kinship carer overseas. But this is kind of like the end of the journey for a child going to live with kinship carer overseas. So it's probably quite helpful to think about an overview. So in all cases where a potential placement of a child with a family member overseas is being considered, the starting point is always to identify the child's nationality and immigration status, because this can determine whether the child will be able to legally reside in the country in question, and linked to this, whether it's even possible for this to take place by way of a kinship placement rather than an inter-country adoption. So this was an issue I spoke about on the last occasion. What we do see sometimes is the issue of the child's potential immigration status in the other country only being considered right at the very end of the process, and it then being identified that, in fact, that there is no option from an immigration point of view for the child to live in the country in question. And so this can cause a lot of time and resources, and the experience of the carers of being assessed. All of these processes being gone through without considering the actual practicalities of the placement can cause a lot of delay and a lot of hardship if it's not addressed at an early stage. If the potential placement is in a 1996 Hague Convention contracting state, this opens up the possibility of using central authorities to cooperate with the overseas authorities, perhaps to obtain an assessment if the other state requires, to obtain their consent to placing the child in that country. And if the potential placement is in a non-contracting state, there are other methods for assessment which I set out on the last occasion. And then again, depending on whether the child will be placed in a contracting state to the convention, this does open up the possibility of considering using the recognition provisions of the 96 Hague Convention to ensure that the child's placement is recognised in the country where they are living. If that's not possible, or if it's in the child's best interest to consider an alternative route, then mirror orders can be explored. So before I take any questions, I would just provide here the information about CFAB's legal advice service. If you have a case-specific inquiry, you're very welcome to email me, and I will provide whatever support and resources I can. And I would also highlight CFAB's advice line, where you can find out more about the full range of services that CFAB can offer. And with that, I will take any questions. Oh, finally, I would say that my colleague Angela is sharing some polls, and we'd be really grateful for your feedback on today's session, and also any comments you'd like to make or suggestions for further sessions. We would be really grateful to hear from you. So one question that we've asked is, how are children protected from honour-based marriages? I think that's a question about the risks associated with potentially placing a child overseas. And I think that is an issue which would need to be addressed in the context of assessment. But you may also find that legal experts overseas are able to provide advice about the extent to which honour-based marriage, forced marriage, is a criminal offence, or is the legislation that is available to protect children from that practice in the country in question. We've also been asked, does it cost local authorities to make inquiries? Our advice line is free, and you're very welcome to send a query to the legal advice service as well, and there's no charge. Our casework services, there are charges, and we can provide details about those, but through our advice line, we don't just provide details about CFAB services, we provide a whole host of information and signposting and resources and suggestions based on our experience in this area. And so I don't think there are any more questions. Oh, I do have a question, I'm sorry. A question about ReJ. The two countries came to a compromise on the order. Has there been a situation where countries don't agree, and does one contracting state have the last say in that situation? Okay, so I think that's a really interesting question. So if you have a 1996 Hague Convention case, everything that I've described today is sort of predicated on the idea that the UK has jurisdiction to make substantive welfare decisions about a child. And so the proceedings have gone through their course and reached a final order, and the UK court has made a welfare decision. And the question then comes about that decision being recognised in another country. And the underlying principle is that that decision should be recognised because it's been taken by a competent court. And that is the principle, of kind of opaque principle of mutual trust underlying the 1996 Hague Convention. The idea that when you enter into become a contracting state to the convention, it puts in place a system of mutual trust and we respect each other's court orders and so on. But it is right to say that there are cases, and you can see them in the law reports, where different countries may make representations to the court about the appropriate outcome in the proceedings in relation to children who have foreign nationality. I think that's probably a bit of an extensive issue for me to talk about now, but it's definitely an issue that has come up in reported cases previously. I've also been asked, can you obtain the recognition prior to the UK orders being made? Most of the time we need that confirmed before formulating the final care plan to see whether it's even a possibility. So yeah, I mean, I think this is a situation where it's really helpful to have advice from an overseas lawyer as to the procedure for achieving recognition, and also a legal opinion on how the order would be recognised. And I say that, and I'm sorry to say it because I know that it's so difficult to have expert evidence, you know, and that there are necessarily costs associated with that. But it does, if you can have advice from an overseas lawyer, it will provide a greater degree of certainty as to what the status of the order will be once the child leaves. And as I mentioned previously, theoretically under the 96 Hague Convention, it is possible to obtain a decision on advance recognition. So a decision from the overseas authorities as to whether they will recognise the order prior to the child moving. The only thing I would say about that is, and I think it's, you know, I think it's something that should be tried, but there are no timescales within the convention for dealing with requests for advance recognition. So it's a bit of a kind of how long is a piece of string issue, and not one that there's an easy answer to. I've also been asked, this is a really good question, is there a cost when completing assessments, both authorities listed in cooperation via central authorities? Usually there is no cost to obtaining an assessment via central authority. There are exceptions to this sometimes, but usually there is no cost. And so it is something that it is worth considering, particularly because some countries do require that requests for assessments do go through their central authority. So in any case where you are working with a child with connections to a 1996 Hague Convention contracting state, I would suggest contacting the central authority. And I think that is generally the good practice guidance anyway. Another question, I find that the central authority do not get involved in the assessment process. Do you find this common? Yes, I think that generally the structure is, and in fact the structure in this country, is that a request for assessment is received by the central authority, and it is then sent to the relevant, the term used is competent authority, so the agency in that country that is competent to conduct the assessment. So the central authority are effectively like the central hub managing the process, but it is then actually performed by a competent authority local to where the family are living. And the same is true for incoming requests for assessment from other contracting states. If they go to the central authority in England, say, they would usually be sent to the relevant local authority where the prospective carer is living to undertake the assessment, and it is then transmitted back to the central authority. Finding experts in other countries' procedures is the biggest issue and a huge cause of delay. Yes, I completely agree with that. Do we have a list? Well, you're very welcome to contact me if you have, you know, in relation to any, because we do have connections with experts in other countries, And where we don't, we are usually able to signpost to appropriate organisations. The other thing that is going to be happening, which I think is a really exciting development, if you're like me and you find these things exciting, the Hague Conference on Private International Law are working to put together country profiles. So every country will be able to set out what their procedures are in relation to cross-border child placement cases. And I think that's what we've been crying out for years now with these international cases, is a resource which sets out precisely what the procedures are in different countries, what we have to do to make sure that the placements proceed in a legally compliant way, and what this means in terms of timescales for the proceedings here, because that's another really difficult issue. So when that is produced, I think that is going to be enormously helpful, and it's probably going to be good timing, as we are only seeing international issues in these proceedings becoming more and more commonplace. I think I will take one more question. So the question about what do you do when the competent authorities assessment is not compliant with the UK courts procedures or frameworks. So this is the issue that we encounter every day at CFAB. How do you obtain an assessment which is sufficient for the domestic proceedings, whilst at the same time being compliant with the procedures necessary in the other country? And so this is an issue. Sorry to defer you to the other session that I presented, but this was an issue which I spoke about there. And what I was talking about really was that often it's necessary to explore using different methods, often at the same time, but it will really depend on the country. And so again, you're very welcome to contact me or our advice line if you have an international case, and we will try and support you with the best way forwards, because it really will depend on the country. So with that, I think I will not take any more questions, and thank you all so much for attending. And again, we'd be really grateful for your feedback. Thank you so much.
Thank you, everybody, for your time this afternoon, and we hope that you've enjoyed this really good session. And thanks to Maria for coming along again to run it for us. Please do keep an eye out on your emails, because we will have more sessions scheduled for in the future, and we'd love you to attend those as well. Thank you very much. Bye-bye.